Mr. Willis.
Thank you and good morning. Thank you for letting us participate. I wanted to just speak very briefly about some of the costs and savings associated with this initiative. When the Lieutenant Governor and the Law Center were drafting this measure, they had three overarching goals that I think we've accomplished. The first is to reduce gun violence in a meaningful way with provisions that work, practical ways of those working. The second is that those provisions should be very cost effective so that the burden on the state or local law enforcement should be minimal or reimbursed. And then the third is that, of course, that these provisions should have minimal intrusion on lawful gun owners, and that was a very important aspect of this drafting. We think we have met all three of those concerns because most of these provisions, the vast majority of them, get to and focus on taking guns and ammunition out of the hands of criminals and convicted felons. That is the point of this measure in large part. And the provisions are targeted in that way. I want to respond or discuss briefly some of the analysis that Ms. Lee brought to, or talk about some of the cost aspects of Ms. Lee's presentation. But before I do, I just wanted to remind us all that in addition to the costs associated with these provisions, we can't lose sight of the savings that occur with even a slight reduction in gun violence. And those are hard to quantify, and so oftentimes they are forgotten, but they are no less important. In fact, I believe they're more important. Even small reductions in gun violence can have tremendous cost savings at the state, local, and of course societal level. There are kind of two aspects of those costs or savings that occur. Not only does a small reduction or large reduction in gun violence make our communities much safer and better places to live, but they also save the state and local entities quite a bit. If you think about any crime scene or any accident scene, there are direct costs associated with every gunshot wound, with every murder or suicide. There's obviously the victims of those shots. They have to be rushed to the hospital. There are direct responder costs and healthcare costs. There's been, in 2010, a report suggested that, a report analyzed that there was a cost of $400,000 per firearm fatality in law enforcement costs alone. So that's an incarceration cost. If you have a criminal, the cost alone is $400,000. You also have investigations and then the incarcerations we discussed. Again, in a 2010 study, the study revealed that there were costs of about $87 million per year related to firearm assaults. And again, both of these studies don't even discuss the significant costs that occur with suicides or accidents. These are just crimes. Then you have, of course, indirect costs associated with gun violence, and those go on for years and years after a suicide or an accident or a crime. And that includes ongoing health care provision for victims. It includes lost productivity in people's lives and in their ability to work. It includes lost income taxes and revenue to the state for people that cannot actively participate in work. The Center for Disease Control in 2013 determined that in California alone, that lost productivity as a result of gun deaths or injuries amounted to a loss of $4.24 billion to the state economy alone. So there are tremendous savings to be had, even with slight reductions in gun violence, and we often lose sight of those. Now I want to address the cost to the consumer, to the gun owner, lawful gun owner, who will be getting be authorized for ammunition, and also talk a little bit about the costs associated with each of these programs. With respect to the cost to a consumer for now complying with the, if this becomes law, complying with the authorization, the ammunition purchase authorization, it's a one-time fee over 4 years, as Ari said, that maxes out at $50 over 4 years. So that's $12.50 a year. That is 4 times less than an annual fishing license or a basic hunting license in the state. So the cost is very minimal. And in terms of and then, of course, once you are authorized, there are no point-of-sale costs associated with that. That is a one-time fee upfront that you can get 6 months before this law takes effect. So there should be no problem with, a consumer wanting to buy ammunition. There should be no delay at all. What does that $50 fee get the consumer, and what does it get the state? Well, it gets you the best of both worlds. It gets you a point of sale that is instant. If the consumer comes in and they are, the seller looks at, determines whether they are authorized or not. If they are, they look at a list on the computer. If they are authorized, they instantly receive their ammunition and they leave the store. There is no waiting period like guns. It's instantaneous. So that's easy for the consumer. And at the same time, it's a list that is updated in real time. So it's not static. It's not like a license that maybe someone was authorized 2 or 3 years before. This is a list that constantly is updated depending on whether someone becomes prohibited or not. So it's the best of both worlds. You have an active list of people that are authorized and taken on and off that list on a daily basis, and it's an instantaneous transaction for the consumer. Finally, I just wanted to talk about the cost associated with this, and there were some questions from the committee to Ms. Lee about that. We feel very strongly that the ammunition purchase authorization program, we looked at this very carefully. We discussed it with a number of stakeholders, including law enforcement, including after we filed with the Bureau of Firearms, and we believe very strongly that this, under just about any model that you look at, will pay for itself. And we even were so confident in that when we initially filed, we said $50 over 2 years, maybe we need to have it 2 years. We looked at that some more during the period by which you can amend, and we became convinced after talking to the Bureau of Firearms and others that a fee of $50 every 4 years would pay for this program. And again, as we mentioned, there is a startup period that gives the DOJ a number of years to get their systems in place. There is a $25 million loan that is available to get the databases in place. And we are, after all, talking about a system that the DOJ is very familiar with. Essentially, we are mimicking the instant background check, or the background checks that occur with guns. And as a result, they are very familiar with that process. And most of the expenses associated with this program, after you spend the initial money for the information technology systems, is hiring analysts who can process the background checks associated with the authorization form. And that's no different than a gun check. And so the DOJ is very familiar with that. They have that system in place. 25 analysts handled 1 million background checks in 2014. No matter how you look at these numbers that we're talking about, whether you have a lot of gun owners that want an authorization form or a smaller percentage, we think that there is more than enough in this fee to pay for itself and to be flexible, because at the end of the day, you're talking about most of the expense is associated with hiring analysts to process background checks, and those costs can obviously go up and down based on workload. And as a result, we believe that this program will pay for itself. We would be happy to answer any questions about the costs, but I think, Julie, you wanted to.
We're done, so we're going to have you stay until the committee can ask questions, but we want to get the opponents in because we have about an hour left, and we want to make sure they get their testimony in. And if you could stick around so we can ask questions afterwards, would be great.
Thank you very much.
Okay. So could we have the,
yeah,
after we hear from the opponents, I want to make sure we get everybody's statements in.
okay. Yeah, please come forward and we'll do, it actually was a little less. It was 40 minutes. So we'll do 40 minutes for the opponents. We need to hear comments from the public, and then the committee will have questions based on everything we've heard, but we do need to adjourn at about noon. So we hope you've divided up your time. You can go in any order you wish and take as much time as you wish
Within that period of time.
within that period of time. Yes.
Good morning, Madam Chair and members of the Senate and Assembly. My name is Michelle Hannessy. I'm a felony prosecutor in Los Angeles County. I'm also the president of the Association of Deputy District Attorneys for Los Angeles County. And I'm here to express both my professional and personal concerns about this initiative. Let me preface my comments by saying I have seen more gun violence than you can possibly imagine. I've tried over 40 murder trials, all but 2 of which included the use of guns. I've seen dozens and dozens of corpses. I've hugged the mothers of murder victims. And I agree that criminals and felons should not have guns or ammunition. Yet I still oppose this initiative on many of the points included in the initiative. As a prosecutor, my concerns are threefold, and the first 2 are specific to the proposed addition of Penal Code Section 29810. First, it places additional burdens on an already overburdened court system for every felony conviction and also for some qualifying misdemeanor convictions. The initiative will require an additional probation report to be prepared, at least 1, if not multiple, additional hearings after conviction, and in many cases, additional investigation and the preparation of a search warrant, as well as the execution of a search warrant, which is a process which requires a lot of resources and manpower, and all by the probation department, which is ill-equipped to handle this workload. My second concern is with the same section, the proposed Section 29810, which is also very likely unconstitutional, as it requires a judge to order a probation officer to conduct a search of private property for firearms if the judge has probable cause to believe that firearms have not been surrendered. Judges should not independently be forming probable cause and ordering search warrants. That is not the way it's done under our Constitution. It totally violates their function as neutral gatekeepers to direct the issuance of a search warrant. The Fourth Amendment talks about probable cause supported by oath or affirmation, and that probable cause and that oath or affirmation are supposed to come from law enforcement and then be screened by a judge, not the reverse. My third concern is on the outright ban of magazines over 10 rounds and the restrictions on ammunition transfers. And the problem with that is that, it's a very honest statement and it might be offensive, but no one will obey those laws. Otherwise, law-abiding citizens have not obeyed similar laws in California. When the city of Los Angeles issued a total prohibition on large capacity magazines, my understanding is not a single magazine was surrendered. It's bad public policy to enact laws that otherwise law-abiding citizens will ignore. It engenders contempt for government and for law enforcement. And finally, on a more personal note, as a gun owner, as a woman who lives alone, who also happens to prosecute violent criminals and gang members, I have personal concerns about the initiative. I appreciate that Lieutenant Governor Newsom thinks I'm a good enough shot to disable criminals who break in my home at night with only 10 rounds in my magazine. But I think that puts me at an unnecessary disadvantage when I'm trying to defend my life in a panic situation against potentially multiple assailants who may also be armed. And that's the problem, is this initiative in every way puts law-abiding citizens, law-abiding gun owners at a disadvantage without doing anything to actually prevent the criminal use of handguns. It's already illegal to shoot people with guns. It's illegal to kill people with guns. If those laws don't stop criminals, some additional infractions and misdemeanors certainly are not going to help. So those are just a few of the reasons that I oppose this initiative. I thank you for your time, and I'd be happy to answer any questions. And I am able to address Senator Leno's questions about normal practices regarding surrender of firearms by prohibited persons.
Thank you, Ms. Hennessy. Salcedo.
Mr. Chair, Madam Chair, thank you very much. Corey Salzillo here on behalf of the California State Sheriff's Association. We are also in opposition to this measure. California, as you know, has some of the strictest gun laws in the nation, and yet gun violence caused by criminals, gang members, and others who are prohibited from purchasing firearms continues every day, as Ms. Hennessy spoke about. California sheriffs are supportive of efforts to enforce the numerous laws that are already on the books against those who would use firearms against our citizens. We're supportive of domestic violence restraining orders. We've supported existing background checks and the waiting periods for purchases of firearms. We've supported bills to restore the prison felony, like AB 1869 by Assemblymember Melendez, to restore the prison felony for theft of a firearm that was taken away by Prop 47. But other than that provision that's included in this measure, the initiative that's being discussed today and will likely be put to the voters will do very little to prevent criminals from acquiring firearms and ammunition via the black market or through theft. Instead, what the measure does is it places additional restrictions on otherwise law-abiding citizens who wish to purchase ammunition for sporting or hunting use, who retain guns and magazines that are currently illegal and that we're told that they would be legal, and to pass historical or family heirloom guns down to next generations. The measure has a particularly unfair impact on collectors of historical firearms, pre-1945 manufactured high-capacity magazines that were previously grandfathered in, which are virtually never used in the commission of crimes, get wrapped up into this measure. And even then, the possession of magazines that were acquired recently under legal premises would be banned, and current owners would now have to turn them in, sell them, or remove them from the state. And the failure to do so would be an infraction or a misdemeanor. It would be unlawful to buy ammunition on behalf of other persons who aren't immediate family members. So a group of hunters, despite what the proponent said, for example, who purchased a large cache of ammunition for everybody in the group, would be breaking the law, as would anybody who acquires that ammunition from someone who says, hey, well, I'll go get the ammunition, you can reimburse me. That's unlawful under this measure. It would be unlawful to go out of state to buy ammunition and return to California with it. So not just the nefarious notion of going across the border to Nevada to acquire ammunition that you can't legally purchase here or that you couldn't legally import, but something as innocuous as going on a hunting trip out of state, acquiring ammunition lawfully, and then attempting to bring back any unused ammunition. That would be a crime under this measure. First offense is only an infraction, but a subsequent would be a misdemeanor. These are just a few of the new laws that would be created by this measure that peace officers would be required to enforce if it's enacted. Effectively, the measure creates a new class of criminals out of those who already comply with existing law and practice and have no intent to otherwise violate the law or perpetrate violence against citizens. Law enforcement agencies will have to undertake new training, new policies and procedures given the significant law changes that are contemplated here. Magazines that were formerly legal to possess will be illegal. Ammunition transactions will be scrutinized, and resources will be used to enforce a set of laws that criminals will simply ignore. The focus of efforts to reduce gun violence should be on those that are responsible for the violence and not those who have no intent to do harm. Thank you very much.
Thank you.
Good morning. My name is Joseph Silvoso. I'm an attorney with the law firm of Michelle & Associates. I'm here on behalf of the Coalition for Civil Liberties. And I knew if I have a hard time getting that out, that would be my biggest hurdle for today. The Coalition for Civil Liberties. Our coalition enjoys the support of law enforcement agencies, district attorneys, as well as law-abiding citizens throughout the state of California. Our numbers grow daily in response to this initiative. The coalition also enjoys the support of the National Rifle Association, the California Rifle and Pistol Association, and Gun Owners of California. What we have here, and I hear the phrase a lot, and what is often touted with laws like these is, these are common sense gun laws. And that always gives me pause, because shouldn't we be talking about common sense laws? Why are laws that we're putting here forth today making criminals out of California citizens, causing a number of them to criminal prosecution, adding additional burdens on our business owners, and last but not least, creating a regulatory scheme which will cause tens of millions of dollars. That's just some of the issues that we'll be addressing here today. But unfortunately for this initiative, it creates more questions than it answers. To start from the beginning of the initiative, we're first going to talk about the theft loss reporting, which a number of you know very, very well because we've seen it many, many times before. And in fact, our biggest proponent, and let me quote directly here, the proponents urge that this law will improve identification of gun traffickers and help law enforcement disarm people prohibited from possessing firearms. I'm not convinced. For the most part, responsible people report the loss or theft of a firearm, and irresponsible people do not. I am skeptical but that this bill would change those behaviors. That's not me saying this. That's not people from the NRA or CRPA saying this. This is our governor saying this when he vetoed a similar theft loss reporting bill a number of years ago. And another bill came before him, and he didn't sign that one as well. We're again here doing the same thing all over again. And somebody please remind me of the definition of insanity, because here we sit again. And here's the concern and the underlying concern with this law. You have victims of crimes, people whose homes have been burglarized. And if they don't report their firearms lost or stolen within 5 days, you're making them criminals as well? Where is the logic in that? Why are we making the victims of thefts criminals themselves? Why are we putting law enforcement in the position to decide whether or not to cite an individual for an infraction because they didn't get to the law enforcement agency in time to report their firearm lost or stolen? As the governor points out, responsible people will do this. Why are we making this a crime? And moving on to the next portion of the bill that's somewhat concerning in our minds is the large capacity magazine ban. Keeping in mind that California, since January 1st, 2000, has prohibited the importation, the manufacture, keeping, offering, exposing for sale, the giving and lending of large capacity magazines, virtually limiting any legal way a person can own and acquire these magazines without certain exceptions allotted for law enforcement and certain permittees. Individuals who own and possess these magazines today have been law-abiding people. They've been law-abiding people and possess these magazines since January 1st, 2000. For 16 years, they've been law-abiding members of our communities. They've been using the magazines for purposes of going to the range, for recreational shooting. Why are we making their lawful possession, despite the fact that they've done nothing wrong, they've done nothing to incur this confiscation, why are we forcing them to take the magazines out of the state, turn them into a dealer, or surrender them to law enforcement? The concern I have with this goes to my day job as a criminal defense attorney. I would really hope that the members and the citizens of this state are as well understanding and know California gun laws as well as I do. I've co-authored a book on the subject. It's 300 pages long. And it's not 300 pages long because I like to write. It's 300 pages long because that's how many laws our members and our citizens have to get through in order to lawfully possess firearms and the things that go along with them, transporting them, using them recreationally. The saddest conversations I have to have with my clients is when I sit across from them and I have to explain them their misunderstanding of the laws. And it happens all the time. And to use a prime example, the ban on assault weapons goes back to 1991. I am still advising clients who are facing very real felony charges that they're facing a substantial restriction on their rights, substantial costs associated with the conviction, and a lifelong conviction on their record because they were unaware. They didn't know that this law has been on the books for almost now 25 years, actually more than that for some of them. And so now we're dealing with another set of laws, and I'm certain if these laws were to pass, I will be sitting across from a table from another person being prosecuted for these laws, or for a violation of these laws, for magazines they've possessed for 20, 30, 40 years. And it's not the people who have extenuated rap sheets that go on for pages and pages. It's a person who, for the first time, has had to talk to me, the first time has to talk to an attorney to guide them through the criminal process. And while the violation is punishable as a misdemeanor or an infraction, unfortunately, when given the option, a lot of our prosecutors will choose to prosecute these violations as misdemeanors. Moving on. Oh, there's been a number of comments concerning the ammunition restrictions and requirements. And am I wrong? Did the LCAV just propose instant background checks for firearms? I thought that might be what they were proposing and saying that it's possible to do for ammunition, but I might have been mistaken. But nevertheless, if we're requiring background checks, and if background checks are the so-called silver bullet when it comes to preventing gun crime, well, there shouldn't be any more gun crime, because under California law, there's no way to transfer, acquire, register a firearm in a person's name without a background check. You can't come into the state with a firearm for purposes of moving here and living here without registering that firearm with the state. It's a background check. You can't give a firearm to Senator Hancock. If I wanted to give you a firearm, and if you wanted to purchase a firearm from me, I couldn't give you one. You and I would have to go down to a licensed firearm dealer, and there would be a background check. If my father wanted to give me one of his firearms, I'd be able to acquire it directly from him, but I'd also have to report that firearm to the California Department of Justice, and there's a background check. If background check is the thing that's going to prevent these things from happening, well, why hasn't it already? And in reading through this and knowing, I'd say a bit about California gun laws and how they work, the thing that struck out to me again for purposes of the ammunition restriction is that I don't think it's entirely clear that the proponents of these laws understand exactly how firearm owners acquire or possess or be compliant with California laws, because ammunition is typically and sometimes often purchased in bulk. I've done it myself. And the way I've gone about it is I get a couple friends together and say, hey, I'm going to be purchasing 1,000 rounds of ammunition. I don't need 1,000 rounds of ammunition, and it's kind of expensive. So why don't we split the costs up? Well, if I'm splitting that between one friend of mine, that's 500 rounds. Not only if he were to purchase that ammunition directly from me, would we both be violating the law, but I would then be considered an ammunition vendor for some weird reason, and I would be violation of the law for lack of a license as well. I don't know why the line was drawn at 500. It doesn't make any sense to me. But nevertheless, that would be the line I'd be crossing, and therefore I would be subject to criminal prosecution for a violation of this section twice. And now, Mr. Cork pointed out some rather significant concerns when it comes to the costs associated with this initiative, and herein is where we find the first of what I'd consider some substantial concerns as it relates to costs. Because in order to enact this ammunition legislation, you're going to be creating not one but two potentially very large databases that are going to, at least one, well, both, will be requiring constant upkeep and oversight by the California Department of Justice. And Senator Hancock, I know you've been monitoring the APPS program and the costs associated with that, and I've been watching from my desk in the office when you've been having those hearings. And your concerns relating to that process and the costs involved rear their ugly heads in this situation as well, because first we're going to have one database that's going to track all of the ammunition purchases. It's akin to the automated firearm system, at least that's what I believe the intent of the author is when they created it. However, when a person purchases a firearm, they may just purchase one firearm. That's, I guess, their choice. But nevertheless, over the years, they will purchase countless thousands of rounds of ammunition, potentially. Each one of those transactions will be an entry into that system. And soon that system will balloon, exponentially so, because as people add to it, they're going to need to add more transactions and more transactions and more transactions to what usually remains a very limited number of firearms that are entered in their name in the AFS. And so those firearms transactions will be entered in over and over again, and soon we'll have millions of transactions that won't be of benefit to law enforcement, because here's the other problem. With ammunition, ammunition is usable. It goes away after you use it. The automated firearm system, the person has the firearm registered to them. You can reasonably and potentially expect them to still possess that firearm. If a person goes to the gun store, purchases the round of ammunition, which gets sent up to DOJ, and then goes shoots that round of ammunition that afternoon, why are we keeping a backlog of all of these transactions over what appears to be an indefinite period of time? This system is going to expand immensely. And the other database system is for the background checks. And we've heard the testimony before about the $50 to pay for the 4-year permit. The problem here is that first DOJ is going to be required to conduct a background check on the individual. That's going to be the first time when the person applies for the permit. However, we're then going to be talking about continuously updating and oversight of that database, because the database will need to, and the initiative requires, that the database of ammunition permittees, it requires them to be updated prior to them attempting to purchase the ammunition. And so what we have here currently with apps will be mirrored with the ammunition purchaser database, in that it will require constant oversight, it will require constant upkeep, and it will constantly require DOJ to make determinations about who's eligible and who is not. And here's where the question, where the costs come in, because now I've talked about 2 rather huge databases that presumably are going to be reimbursed by a $50 fee that a person pays once over a 4-year period. The initiative asks for $25 million. I unfortunately think that it's far more likely that this legislature will probably be having hearings concerning more money and DOJ asking for more, versus that fund and that loan of $25 million will be repaid. And I did have another question when LCAV was concerned and saying that the total costs attributed to gun owners would just be that. I guess it broke down to $12 a year, because I think they're failing to take into account all the costs that are now going to be incurred by the vendors or the dealers in that ammunition, because the added background checks, the added employees, the addition of the certificate of eligibility requirement for all of the employees will not just be absorbed by the dealer, but nevertheless will be attributed and transferred over to the firearm purchaser. And so when they tell you, oh, don't worry, it's just going to cost you $50, I have some concerns with that. And then last but not least, having to deal with the felon turn-in, as I like to call it, or the requirements that a convicted person turn in their firearms. Again, while in theory, I think it has and potentially has some merit, but in execution, it's flawed 5 ways to Sunday. when a person enters a plea for a conviction or enters into a plea agreement with the district attorney's office, that plea and conviction is happening right then and there, that day. However, we're now creating a mechanism and a procedure in which a person will enter their plea, and instead of having the case over and done with right then and there, you're requiring that the court and now probation conduct additional work in association with the turn-in and the forfeiture of these firearms. And I mentioned probation because probation will have the lion's shares of work in this situation because the person convicted will have to fill out a report, potentially in violation of their Fifth Amendment rights. It's stating where and how many firearms they have. That report gets turned over to probation that does a check of the automated firearm system. Probation will have to, and in a very limited period of time, make a determination whether or not that person who, once they turn in their firearms, has complied with all of the requirements set forth in this initiative. I know probation very well. They look after and are looking after some of my clients right now. But nevertheless, they are extremely overworked, they are understaffed, and this initiative will swamp them with additional research, paperwork, and reports they will have to write in order to advise the court of whether or not the defendant has complied with all of his or her requirements. And again, that gets us back to the court. The court's going to have separate hearings for purposes of whether or not that person has made the determination, has turned in the firearms as required. The additional costs, we have serious concerns, will not be recouped when it comes to these requirements. And last but not least, I don't think it's going to do anything to advance the concerns set forth in the initiative. Again, we're talking about, and we always hear the phrase common sense. I'm having a very hard time finding the common sense here. If mental health is a concern, why aren't we addressing the mental health concerns? Why aren't we giving more money instead of the $25 million to be thrown away in needless databases to the hospitals, or removing the stigma attached to mental health? If we're concerned about youths getting access to firearms, why aren't we attempting to educate the members in our schools instead of making firearms a suspendable, or discussing firearms a suspendable offense? I see Mr. Sawyer.
Well,
wanting to move on.
using up Mr. DeLuse's time unless he wants to cede it over to you.